All rise. Court Appeals Division 1 is now in session.
Please be seated. Good morning. This is the time set for argument in 1 CA IC 210015, Garcia versus the Industrial Commission of Arizona. And counsel, we've read your briefs. We've discussed this matter in conference this morning. When you approach the podium, if you would please state your name for the record. Both sides have 20 minutes to present your arguments. And with that, we'll hear from the petitioner.
Good morning, Your Honors. My name is Dennis Kurth, and I'm an attorney with the law firm of Snow, Carpio, and Weekly, and I'm here to represent the petitioner, Alex Garcia. Mr. Garcia was a heavy equipment operator who described driving an excavator, which resulted in him bouncing and rocking and jarring and crashing. And his doctors claimed that that work activity contributed to the symptomatic spinal stenosis that he developed, and which was the basis for his industrial claim. The case went to hearing as a typical industrial case with conflicting medical evidence. The defendants came up with an independent medical exam with a doctor who said that there was no relationship between the work activity of an equipment operator, such as the claimant, and the symptomatic spinal stenosis that he developed. So the doctor, Dr. Young, who testified for the respondents, hinged his opinion in great measure. He said...
well, that's your opinion. Let's cut to the crux. When the ALJ said, do you want to recall the doctors? Why didn't you do that? She gave you 2 weeks to notify and to recall the doctors.
Okay, Your Honor, first of all, I didn't represent...
I'm talking, when I say you, I mean your client.
Right.
Why didn't you do that?
That's a good question, and I can't answer that.
I try to ask good questions.
Okay. He, of course, passed away in January after suffering from multiple myeloma for several years and in and out of the hospital. Other than that, you're right, I can't answer. My answer, however, is this. The respondents withdrew their objection to that article, and the judge...
Hold on. Without any explanation from the doctors, you're asking a non-medical professional to evaluate an article in an area that requires expert opinion. So, yes, it was somewhat impeaching, but to the degree of impeachment, it is problematic unless you actually call the expert to explain how this impeaching evidence would change or not change the testimony of the testifying medical expert. And she gave you that opportunity, and you didn't take advantage of it.
However, Judge, and you're absolutely correct, I think it's clear enough from that article, and these articles, you're right, these are very, very difficult for lay people such as lawyers to understand. It's very bad reading. It's not very interesting when you're reading about these studies, but there is enough in this study to be able to tell that the ALJ misinterpreted that article. You can tell just by looking at it that it contradicts Dr. Young, and it supports...
Well, let's talk about that for a second.
Sure.
First of all, where was it published? This article, where was it published?
Apparently it was on the CDC NIOSH, National Institute of Occupational Safety and Health, website published in 2004.
Did you provide a URL so that the ALJ could verify that?
I'm sorry, Judge?
Did you provide a URL so that the ALJ could verify its publication?
I believe Mr. Snow did.
I didn't see it.
Okay.
I mean, I'm just saying, if you knew where in the record it would indicate that a URL was provided?
Not unless it was in Mr. Snow's letter filing the article with the judge.
So that it was filed. Does it indicate it was a medical article? I mean, this was not a peer-reviewed article, was it?
Yes, it is a peer-reviewed
By
article.
whom was it peer-reviewed if it wasn't published in a recognized journal?
I don't know who it was peer-reviewed by, but it was filed as a peer-reviewed CDC NIOSH article, which the National Institute of Health, of course, is considered as a prime source of medical information.
Well, I'm not trying to be difficult here, but the CDC has a lot of stuff on their website. Not all of it has been peer-reviewed by the CDC or any Institute of Health. That's what I'm saying. Did you give a URL so that someone could look at that and determine whether or not it had actually been peer-reviewed?
I think so, but I don't know. But with all due respect, Your Honor, nobody raised that issue, and the judge considered it, and the judge summarized it in her opinion, and it's pretty objectively easy to tell that she misconstrued it by looking at the language that she quoted from that article as support for Dr. Young and the actual conclusion of that article as our brief sets forth.
Doesn't the article itself say the bottom line is more data is needed? It doesn't really reach a conclusion because it says we need more data.
It says we need more data, but, Your Honor, if you take a look at that summary of the article, it is pretty clear what their viewpoint is. It starts out, previous studies have indicated heavy equipment operators are afflicted with musculoskeletal disorders. From this review, it is shown that the whole body vibration and postural requirements of work are important risk factors that contribute. Not
Does it give a citation to any of those studies?
all of the studies are listed in there, and they go through the studies one by one. There's about, I counted about 19 studies.
Peer-reviewed. And I guess my problem is their recognition is they say that, but they also recognize that there's more data needed, which seems consistent with what Dr. Young said, is there's not enough out there for me to say that that is related.
Well, I don't believe that, Judge. I believe that what they're saying is that these vibrations of the machines and the awkward posture of an excavator operator, for example, are important risk factors, not just risk factors, and contribute, not may contribute. And then they go on to say, in spite of this, what they're referring to is all those studies that they go through one by one, only one of which contradicts their conclusion. So what they're doing is they're recommending more research, but they narrow it down and they're specific. They say we need to see more research on the quantification of vibration and postural requirements. So I think what they're saying is,
Well, haven't you just made the point? 2 layers can sit and talk about that, but the person, and this is consistent with what Judge McMurdy's really good question, is the issue is it's the doctors that need to tell us, because 2 layers can mince those words. But it's not about us mincing those words in the article. It's about the doctor telling us how those substantial, those issues that you're talking about work in this case.
You're right. It's more important what the doctors think about it, but what the judge said about this article is wrong. If you look at the article, this man was a heavy equipment operator, subject to these emotions, and the testimony that he gave described this type of vibration, not just, the more extreme of this type of vibration.
But without a doctor, how can I say that the judge is wrong? Well, because the problem is you're trying to interpret that article in a way, and we're not the doctors to interpret it.
No, Your Honor, but we can read the summary of it, which says important risk factors that contribute. We need more study of this in terms of, clearly, if a doctor had seen this article, you would say, yes, this article does support the connection between the vibration of an excavator machine and the development of low back pain.
I think maybe you can read it and say it suggests that But I don't think I, as a layperson, can sit here and say it supports it. I think that's a doctor that needs to say that.
Would be helpful, sure. But the judge took it a step further and went and characterized it herself. And if she characterizes it as wrong, or she mischaracterizes it, there should be something the court can do to rectify that, send it back again for the judge to correct it again. I mean, if you look at the...
She already gave you an opportunity, and you blew it. She gave you an opportunity. She said, call the doctor. And you didn't call the doctor. Right?
My predecessor did not call the doctor. He was...
Again, I'm not throwing a stone at you. I'm just saying your client didn't call the doctor.
That's correct. No way I can argue around that. All I can say is the summary of this article does not indicate what the judge said it indicates. And the judge also made a couple other comments like, well, there's nothing that says spinal stenosis in here. Yet the rubric musculoskeletal disorders covers spinal stenosis, a very common low back problem, especially in the workers' compensation setting. The judge said that the applicant, the claimant, the petitioner, didn't testify in terms of whole body vibration. Well, that's not really important. Everything he described in terms of his activity and his physical presence on the excavator fit within the definition of whole body vibration. I think if the judge, the judge could have said, I can't interpret this article, therefore it doesn't support the applicant, but the judge stuck her neck out and said it does support the applicant, and it's pretty easy to see that from the conclusion of the article, the judge wasn't necessarily right about that, nor was she right about the applicant not describing whole body vibration or anything else of that nature. So I think if the judge makes that a point and interprets that article in a particular way, if the court can determine that the judge made a mistake in interpreting, I mean, you can tell just by the cite. The judge took that word may contribute and not enough evidence to establish a connection from a single study that's in that article, not from the overall article. The overwhelming theme of the whole article is that there is a connection between this great vibration sitting on an excavator or other heavy equipment and the development of low back problems. In fact, based on my experience, it's pretty counterintuitive for Dr. Young to say that for a person who gets bounced up and down on an excavator, there's no relationship between the development of back pain while he's bouncing around on the excavator.
Your client isn't seeking something for back pain. Your client is here saying this caused spinal stenosis, not back pain. So where is there something in that article that would say spinal stenosis? Because you said the rubric out there, but the article itself doesn't address spinal stenosis, and Dr. Young's point was the things that they're talking about, the bouncing around and stuff, doesn't cause spinal stenosis. So I'm struggling with how the article gets you there.
Well, as I said before, spinal stenosis is simply one of many different musculoskeletal disorders of the lumbar spine. That's true. They don't use the word spinal stenosis. Bouncing around on an excavator doesn't cause, and nobody ever meant to say it causes spinal stenosis. Spinal stenosis is typically a degenerative condition. What bouncing around on an excavator causes is the spinal stenosis to become symptomatic. And that's where I'm saying it's kind of counterintuitive to think that bouncing around like excavator operators do doesn't aggravate spinal stenosis. We don't have to prove that the bouncing around on an excavator caused the actual anatomic spinal stenosis. We just have to prove that it made it symptomatic and made medical treatment necessary. So, Yeah, I mean, they don't use the term spinal stenosis, but it's a very, very common aspect. They talk about degenerative disc disease and things like that. The whole point of the applicant's claim is that that bouncing around made that pre-existing congenitally based condition symptomatic, requiring medical treatment. That was the whole point, not that it caused the spinal stenosis. These are very common cases that go in front of the Industrial Commission.
But how do I read an article, again, as just a judge, no different than the ALJ really, and conclude that I can go beyond the words of the article, disc degeneration, things like that, and say spinal stenosis is part of that too? That's a big step for a layperson to do.
And
There may be some common sense to what you're arguing, but it's not common sense in a real way. It's a medical diagnosis.
And like I say, Judge, it would have been great if Mr. Snow had requested that the judge hold the hearing for the doctor. That would have been preferable. On the other hand, the judge made comments about the article, affirmed her decision based on the article. The whole case, the whole award is based on the integrity of Dr. Young's opinion, which if he's wrong and if there is medical literature that supports a connection, then we would have to conclude that his testimony lacked foundation and should not be considered as substantial evidence to support it. You could still remand the case back to do that, to take medical evidence. That's what the court did in Desert Insulations, the seminal case on the lack of foundation. They said that the problem that was pointed to as the lack of foundation wasn't necessarily a big thing that would cause the court to completely disregard the doctor's opinion, but that it quote, merited the ALJ's attention. So it doesn't have to be something, but in this case, I think it is. It was very prominently, as Dr. Young said, a factor in his opinion. You would think that as a board-certified spinal surgeon, offering an opinion that the bouncing around on an excavator doesn't aggravate spinal stenosis would be familiar with the article and with the medical literature, but I think Dr. Young said, well, there's no medical
Did your
literature.
client's doctor talk about this article? Because it seems to me nobody seemed to be aware of this.
You would think you would be aware of it, right?
But no, I'm talking about your client's doctor. Is there any suggestion that your client's doctor was aware of this and had used this or relied on this to back up your doctor's theory?
It really didn't matter because the doctor who testified for the petitioner, Dr. Scott, was of the opinion that that work activity aggravated the spinal stenosis. So he didn't mention that article, but that was his
Any other
opinion.
literature?
Pardon me?
Any other literature? In other words, did your testimony at the trial in any way impeach Dr. Young's statement about literature?
Not until after he testified that his opinion was based on a lack of medical literature. Your Honor, if I may, I would like to save my last 3 minutes, please.
Thank you. Good morning.
Good morning. My name's Sharon Hensley. I work at Copperpoint. I represent the respondents in this matter. I think it's pretty clear that the sole issue in this case is whether there's any reasonable evidence to support Judge Bodie's adoption of Dr. Young's opinion. And Dr. Young is a fellowship-trained spine surgeon. That's all he does, spine surgeries. He didn't say that his opinion was exclusively based on the lack of an article or medical literature. He did say that he was unaware of any medical literature that supported it. And the article that was ultimately reviewed by Judge Bodie is not contradictory of Dr. Young's opinion. You're correct that it says things like, we need more evidence. It talks about general discomfort in the spine. It doesn't talk about stenosis, spondylolisthesis, spondylosis, there are so many, degenerative disc disease, compression fractures. There's many disorders of the spine, all that have different causation. In this particular case, Mr. Kurth is correct. He's not arguing that operating a equipment caused the spinal stenosis. He's saying it caused it to become symptomatic. There was a conflict in the medical evidence. Dr. Scott said it did. The fellowship-trained spine surgeon said it didn't, and he did not believe there was literature to support it. And I do not believe the article contradicts that in any meaningful way.
So,
Go ahead. No.
no, but the article talks about specific conditions that are aggravated by this.
It makes reference to a herniated disc, I think, at one point in the article. It certainly does not talk about spinal stenosis or causing spinal stenosis specifically to become symptomatic. And although Mr. Kurth indicated that it is common sense, it clearly wasn't common sense to a fellowship-trained back surgeon who testified otherwise. And we have to look at the actual medical testimony and rely on the experts, because as you all say, we are not the experts and neither is the judge. The articles are somewhat complicated, although in this case, I think the best that can be said about the article is that operating some heavy equipment in clinical settings, not in real-life situations, as they indicated most of them were, combined with sitting in awkward positions, which there was no testimony about in this case, might cause some disorders of the spine. That's not contradictory to Dr.
And that's
Young's
my
opinion.
point is, it's about causation, but not necessarily about aggravating.
I think that's true. I think they do talk about causation as opposed to aggravating an underlying condition. That was my point, is that the article does not talk about congenital stenosis or congenital spondylolisthesis, both referenced by Dr. Young, and then an aggravation or a symptomatic aggravation of that. I just don't think the article is particularly on point.
And is it written by doctors, or who did this analysis?
I honestly do not know. I didn't think it was my obligation to look into it. I agree with you, Judge. I think had Mr. Garcia believed that the article truly was more than, I think Mr. Snow indicated in his request for review, the article, quote, arguably is contradictory to Dr. Young. I think he probably recognized it was not a particularly strong article. That being said,
I'm confused why you would withdraw your objection to the ALJ, considering it, given the lack of medical testimony regarding the article, and looking at the article itself, the lack of indication of who prepared the article, their background, whether it had been peer-reviewed. I mean, why would you withdraw your objection to that article?
it was a judgment. I had reviewed it, and those things you're talking about, if the judge doesn't review it, she really can't look to those things. I honestly did not want to create a potential appealable error by having her not look at it. It would have been her choice. She has the discretion to look at it or not look at it, and I just thought I would err on the side of caution and allow her to look at it because I did not find it to be very important. I hope that answered your question. If the court has no further questions, I don't know that there's anything that I can offer beyond what was in my answering brief.
All right,
Thank you for your time and
counsel.
consideration.
Mr. Kurtz.
Thank you, Your Honors. So, yes, I do want to call your attention to Mr. Snow's letter to Judge Bodie of November 18, 2020, in which he did provide the URL that you were seeking. So it's in the record. It's the correspondence of November 18, 2020, and he says that the article is listed on the CDC website. It's not an abstract or less well-known journal, and he provides the URL for the article. Getting back to my point is that the judge considered the article. The judge hung her hat on the article in affirming the award. The article,
Well, I'm just going to, the judge hung her hat on a whole lot of things, not just the article. There was also a lot of testimony that the judge relied on.
the other
Would you
things,
disagree that there was more that the judge didn't simply say, well, given this article, I'm going to rule against your client?
well, I think it was critical to the judge's affirming of the award in the decision upon review, but you're right. She also said that the petitioner didn't describe any whole body vibration. Well, of course, petitioners, heavy equipment operators, they don't go around talking to their buddies about whole body vibration. They talk about jarring, crashing, rocking, slamming. That's what they talk about. So she was wrong. What he testified about was considered whole body vibration. In fact, probably the most extreme of whole body vibration. So I think she was also wrong about that. She was wrong in saying that the point of the whole article was that there's not enough evidence of a causal relationship. And I think that's pretty apparent from the summary paragraph, is that there is a connection. That's what the whole study was about. So I urge you to please reconsider and review the summary of the article. Look at the language that the judge quoted from one study in the middle of the article, which was negative, and you can see that she could have just quoted the language in the summary and said that the article does support the relationship, the connection between the vibration of a heavy equipment operator and the development of a symptomatic spinal stenosis. And again, I don't think it's a big deal to the fact that spinal stenosis is not a herniated disc or something else. They were talking about low back pain, and all those studies indicate that the operators of the heavy equipment had extra or higher incidences of low back pain, whether it was stenosis or disc or anything else. Thank you.
All right, thank you, Mr. Curve. The matter will be deemed submitted. We'll issue a decision in due course.